I know we are all pretty much familiar with that, but nonetheless, it may make sense to summarize that briefly and the whole situation so we are all on one page if we start into the discussion. Starting from the beginning, from EU law perspective, whenever a company intends to share data with a recipient outside the EU, it basically, or in most cases, needs to apply certain additional safeguards for that, because the recipient will most likely not be subject to EU law, and in particular not to GDPR. That's why this has to be established somehow. Most of the tools offered by GDPR are kind of bilateral understandings between the data exporter and the importer, in which the data importer obliges themselves kind of to maintain certain minimum standards of data protection when handling personal data. In the last years, we have seen a certain development here, so that the two key tools which were used for that purpose were, on the one hand, the so-called standard contractual clauses approved by the EU Commission, and on the other hand, particularly for the transfers to the US, the EU-US Privacy Shield. So that was the practice until last year, basically. If you wanted to engage a service provider in the US, for example, like a cloud service provider, you checked whether he's registered under the Privacy Shield. If that was not the case, you would have to sign the standard protection clauses, and that was fine, and you could go for it. Until mid last year, of course, then enter European Court of Justice, which basically held that both the standard contractual clauses as well as the EU Privacy Shield that actually not provide for a sufficient level of data protection and were more or less invalidated. And by this move, the court basically more or less destroyed the legal basis for thousands actually of data transfers between the EU and the US. The key reasons the court shared for that were, on the one hand, that those more or less bilateral means did, of course, not affect the practice of secret services and other investigative authorities who could still tap into the data transfer to the US servers. And on the other hand, the EU data subjects, which were affected by that, they were not provided with a sufficient level of transparency what happened with the data, and of course they were also not provided with sufficient rights of redress, so they could take legal steps if they believed their rights of privacy were infringed. Yes, that's basically the picture since last year, and we have not seen yet a sufficient, comprehensive, and reliable mechanism to overcome this problem. But there have been some approaches in that way. So for the one hand, the EU Commission moved end last year and provided drafts for new templates for standard contextual clauses, which also addressed some of the topics raised by the European Court of Justice. But to be honest, the key background for these new templates were basically that the old templates were about 20 years old and needed urgently some update. So they did actually not provide for a full remediation of the issues identified by the European Court of Justice. And on a second level, also the European Data Protection Board, the EDPB, also took a stand and released guidelines for additional measures to be applied by data exporters if they want to share data with companies outside the EU. That was also fine, but to be frank, many of these guidelines provided for a very high threshold and actually are in many cases probably not enforceable by companies sharing their data, and they simply don't fit to many data sharing models we see on the market. So this is ultimately what it all comes down to at the moment. We see EU companies, and nearly every EU company in some way relies on one or even more cloud service providers based in the US or somewhere else outside the EU. Be it if they use Google Analytics on the websites, they use Microsoft Azure, they use Amazon Web Services. They, of course, so as we do, they use conference tools who also share data in the US mostly. So they all have a huge problem there. And all these companies find themselves in kind of a take it or leave it decision at the moment. So either they take the risk and go on using the services and risk being fined actually for breach of GDPR, or they ban the services from the company, but they are mostly told from a commercial perspective that this is actually no-go because we don't have sufficient substitutes of the service providers located in the EU. Not yet, or not generally available to everyone, or not affordable generally. So all these companies are in a huge problem right now. And yeah, we see many companies who, for the time being, decide to take the risk actually, but that may of course change very quickly once the supervisory authorities decide to go after these companies and issue fines and so on. So once this starts, this will of course provide for a very different scenario. And this finally brings us to the whole topic of this webinar, the codes of conduct, which may potentially provide for a different regime to overcome the issues identified by the European Court of Justice and meet the requirements of GDPR. And for this purpose, I will hand over to Jörn, as he's a real expert on the field of co-regulation, and he will share some thoughts. What are codes of conduct? What can they do? What are pros and cons with you? So Jörn, stage is yours, please.
Yes, Thomas, thank you very much. So my intervention will be split into the three parts. The first is a short explanation of actually what codes of conduct under GDPR are, just to make sure that we're all on the same page. Then I would like to explain the general structure of the EU Cloud CoC and how this whole idea of the third country data transfer tool tailors in. And last but not least, I would like to share with you a first idea where we think that codes of conduct are not only a tool that could be redundant to other tools, but actually provide added value. So jumping first into the topic, what actually are codes of conduct? So first of all, we all know that GDPR is a regulation that was designed to be future-proof. But in order to be future-proof in a highly innovative environment, of course, you have to stay away from technical details of the regulation, which at the end of the day, of course, led to a lot of very vague provisions. I think that all of the experts here on the call are very well aware of that. So, but the regulator actually knew about the problem, and that is the good news, and implemented several mechanisms into the GDPR to overcome that issue. Because also the regulator knew that they cannot wait, or it would be too risky to wait for court decisions to really make sure that GDPR is implemented properly. If you have one decision and at the same time 5 new technologies emerge that already need a different kind of implementation of GDPR. So that wouldn't work out. One of the mechanisms they were thinking of was actually codes of conduct. And with codes of conduct, the regulator gave the industry the possibility to say, okay, here's a vague provision, and we think this could be a proper implementation of GDPR. And of course, they cannot decide for themselves. With that idea, with this draft of a code of conduct, they can approach their competent supervisory authority and ask for their opinion. In case that more than one member state is concerned of this topic, the EDPB must be included in the whole decision. And once the data protection authorities and the industry agree on the text, there will be an approval of the code of conduct. Important in this regard is also the approval can only be performed in case there is an independent monitoring system incorporated into the code and appointed. I will get back to this later. And once all of that comes together, the approval, the agreement, the approval, and also the monitoring system, you can use, the industry can use a code of conduct as a proof of compliance. Now I would like to share my screen and give you a short view on how that whole thing tailors in, I will do it like that, tailors in our current code of conduct. So you might know, some of you might be aware of the fact that the EU Cloud CoC will be the first code of conduct that will be approved by the EDPB for all cloud layers and for the whole cloud industry, with a focus on Article 28, so as a processor, and in order and will provide sufficient guarantees pursuant to Article 28, Section 5. That is the idea of our baseline code. So the third country data transfer module now comes on top of that. So it's not a completely new project where we try to design everything from scratch. We add where we think it's necessary to actually legitimize third country data transfers based on the code of conduct. So that would mean that every company that is a member of the EU Cloud CoC can subscribe services to the baseline code and can then choose whether or not that certain services of those already subscribed should be part of the third country data transfer module. So only for services, of course, where third country data transfers occur or where the company decides that the other tools they are using are not sufficient. I can show you a small overview how that works out, because actually from the very beginning, the creators of the EU Cloud CoC were very much aware of the fact that when creating a baseline code for cloud, that creates, of course, tremendous added value. But on the other hand, there will always be sectors that will need further specification or maybe even additional requirements. So the idea was always that we create a baseline code, we get the approval for that, and that will soon happen very, very soon. And then we add modules that specify cloud usage for certain sectors. So the examples here are the financial sector, the health sector, and so forth. And of course, the third country data transfer module will be one of these tools. Now jumping over to how actually we think codes of conduct can be of added value. So of course, it's a redundant tool, which is great because we have seen in the past, and Thomas described that very well, that the tools existing you cannot really rely on. It can always happen that one breaks away, so you might need a redundant solution. But we also see from the Schrems II ruling that we need more specific solutions for sectors. We need more specific requirements for processors that the controller is actually able to judge whether or not a data transfer makes sense. But what we've also seen is with the Schrems II ruling that a lot of requirements are put in the hands of the controller, where we think, and I think a large part of the market shares that thought, is that we think the controller cannot perform actually the assessment on their own. And the result would be that either they just trust something or just have to do it because they need it for their business, or they refrain from using the cloud, which of course would be a huge problem for European economy. So what we were thinking of, how to make sure that the controller gets, how the controller can get all the information he or she needs to actually make a decision about the data transfer. But, and that was actually something that came up from some DPAs in the past, is not putting the responsibility in the hands of the processor, in this case, the cloud service provider, because we cannot just shift the liability over there, and also the cloud service provider doesn't have all the information necessary actually to do that job. So what we were thinking of, and I have to put in a short disclaimer here, this is a first thought. It's not really negotiated yet, and we have to see how the requirements will look. But the first idea is we want to use the independent monitoring system that has to be there, and it's mandatory for every kind of code of conduct anyway, and so to say, build something on top of that that helps to overcome certain issues related to the Schrems II ruling. And of course, we think one of the main issues of the Schrems II ruling is actually the assessment of the legislative environment in the third country. So what we were thinking about is that we might implement certain only notification obligations of a cloud service provider in the direction of the monitoring body regarding the legislative environment in the country. So, by the way, this doesn't have to be done necessarily by the cloud provider. itself. It could also be performed by an agency doing that. But in any case, the monitoring body receives certain information. Based on that information and based on the code we have developed until then, there will be a catalog of supplementary measures. And the monitoring will look at what they were informed about and will look at the catalog and select supplementary measures to make sure that the data transfer is compliant with European data protection law. But of course, I mean, I'm the managing director of a monitoring body, so I'm also not very keen on getting certain liability issues here in-house. So of course we have to make sure that this whole system works. If we make a decision that large cloud providers have to implement certain supplementary measures, maybe hopefully only as an exception or maybe never, but it's theoretically possible, even stop the data transfer, we must make sure that that really is the right decision. So we were thinking of also having a notification and also interaction possibility with the supervisor, with the competent supervisory authority, that in that sense would help to legitimize the decision of the monitoring body. And by that, and you can see that now in this large circle that you can see here on screen, the controller gets a safeguard mechanism and certain information he or she needs to make a decision and can only take the box, maybe not for everything, but for a lot. We don't put the responsibility in the hands of the processor. So that is our idea for a certain thing where we think codes of conduct can be of added value. And by that, Thomas, I give back to you.
Well, yes, thanks, Jörn. That was very much information in a very short time, so perhaps we will have time to discuss certain of that in the following. But yeah, as time is short, I would very much like to hand over to Natalie right now, because she can also give some insight into what is currently going on at the US cloud provider, from that perspective, and what is done there post Schrems II. And so without further noticing anything else, I would hand over to Natalie.
Thank you, Thomas, and thank you, Jörn, for the great introduction. It's a pleasure to be here. Thank you, Scope, for the invitation. Maybe I'd like to share thoughts regarding challenges and from the cloud side perspective, also maybe what are we doing and also our views on the code of conduct. So starting with the first part, I think that there's at least two main challenges. Not only for the cloud industry, but for organizations in general and privacy practitioners that are, first, that adequacy decisions are left in hands of the private organizations. And this is something that Thomas already mentioned. So we have moved from two frameworks that gave us robust and clear tools, and that was Privacy Shield, model clauses. We had clear rules of the road. And now we moved into a scenario in which we have draft recommendations that are kind of the different pieces of the puzzle that we need to ensemble together in order to make a decision. So that's a huge shift when it comes to the assessment, when it comes to the accountability exercise, the resources you put into it and the like. So I think that's the first challenge that we have on the table. The second thing we observe is that actually, you know, the vast majority of organizations don't really have the resources to support massive, sophisticated compliance, privacy compliance exercises, especially when it comes to SMBs. So organizations are right now focused on navigating the pandemic, enabling remote working and collaboration, focusing on economic recovery and on digital transformation, how they can be more competitive. And kind of what we see is that for them, like removing the technology that have made them resilient and competitive during the pandemic is kind of not an idea that can embrace. So there's the two challenges that I like to bring to this exchange. Now, when it comes to, hey, what are you doing or how are you helping navigate this post-Schrems landscape? I think as a cloud provider, you need to be there for your customer in terms of facilitating risk assessments and compliance exercise in the extent is possible. And how you do that? So you do that, I think transparency is key, and clearly answering questions like, what are your technical measures? How are you encrypting data in transit, at rest? What are your key management capabilities? What are the possibilities for the customer to manage a key, or for a third party to manage a key in a jurisdiction that they are comfortable with, under applicable law that they are happy with? What are your data residency options, even though that's not mentioned in the recommendations? So that it's about control. It's about customer like sitting on the driver's seat regarding what they do with data management. How do I get transparency about who gets access to the data? So these are the sort of technical questions. Then being very transparent about your contractual commitments, being very transparent about your organizational measures, things like as we saw in the draft recommendations. Do you embrace, have you gone through third-party audits and certifications, international standards? Do you have a data protection officer? Is your internal audit checking on your privacy controls in terms of design and effectiveness? So do you have a robust process for responding to government requests? What do you do when you receive a government request? Do you notify your customer? Do you limit the disclosure to the minimum data as necessary? Do you challenge the request as appropriate? Do you give transparency on the overall like volume of, or you know, activity that you get on this front? So I think that transparency and being there to answer the right questions in a scalable manner, it's important. Also, I think part of the equation for everyone, and this equation is to engage in the conversation constructively, as we are doing today. I think, for example, providing feedback to this public consultation process for the draft recommendation was important. There are things that, you know, like fully align with long-standing industry practices. There are other things that could be improved because they could be really challenging in practice in terms of how technology and how the internet works. So engaging from everyone from its position with its experience, providing ideas, I think it's important because it's a shared responsibility to come up with a solution that works and that is robust and that can help resolve this kind of limbo where we ended at. Then touching on why or the value of codes of conduct and building upon what John just said, I think that at Google Cloud we decided to become one of the first supporters of the code for a number of good reasons. First, we believe that a code is an excellent tool to promote trust and accountability, and you promote trust by describing and providing transparency, like this is the way where you describe your operations, how sub-processors work, how this portability works in the cloud, how deletion should work in the cloud, security, physical security, logical security, personal security. So that's on the transparency side. On the accountability side is the tool that you have as a provider to demonstrate compliance, but also it's a tool for customers to demonstrate their own compliance with their customers, with their auditors, and with the regulators eventually. So ultimately, we believe that this is a tool that makes our customers' lives easier. And second, and I think very importantly, we believe this is an extremely good collaboration tool amongst industry players and data protection authorities. It's about how we can possibly implement the letter of the law in a robust manner and in a way that aligns with innovation, with technology, in particular with the cloud. And beginning into the right to audit example. So every customer will have a right to audit per GDPR. Now, cloud solutions are intended to scale to millions of customers. How do you operationalize that in practice? Because actually, like having hundreds of people working around a data center is not a good idea. It actually jeopardizes, undermines security and puts at risk the whole customer base. So how you navigate this? So thinking together, working together creatively to come up with this workable solution. I think it's a huge benefit of having this codes of conduct as a additional data transfer mechanism in addition to others that you may have. So now we have the opportunity to leverage the advantage of these codes of conduct for international data transfers. I think this is a promising exercise, and we live at a time where robust and durable data flows compliance mechanisms are not just important but urgent. So I can only encourage cloud customers and providers and practitioners to join this initiative with their expertise, and so we work together as an industry to come up with robust, durable solutions. And with this, I get back to Thomas.
Yes, thank you, Natalie. That was also really informative. Thank you for that, and that was, I believe, a perfect handover to our Q&A session. So I described the mechanism already before. We will be able to allow you to unmute, but to show that you would have to raise your hand first. So if you have any questions, comments, or anything to add, to ask, whatever, please do not hesitate. If you don't, I will definitely have some questions to my other co-speakers, because of course, I have also some need for knowledge here, which they will probably be happy to share with me. So, anyone? So I don't see a hand right now. So then I will just take it up. Perhaps you may want to chime in later. So I would like to ask to Natalie, for example. So what is your personal view on the importance of global data flows? Because that's what's all behind it. And do you think there's actually a need to keep them alive, or should we just stick with what the European Court said, more or less, and say, okay, cut everything off, and that's it from now?
That's a great question. I do think that international data flows are vital to the digital economy. We can't just not live without them. It's EU companies have operations overseas. Even small companies or startups, they aspire to have customers internationally. How can that possibly happen without international data flows? I ultimately think that EU organizations, big and small, they should be able to access the best technology in the market, regardless of the location of that technology. Otherwise, they will have a competitive disadvantage. Of course, we need to make sure that there is compliance with European fundamental rules and values, and I think that is the process we need to engage on, but not in isolating European and companies from accessing, as I said, the best, whatever the location is. So I think also the location of the data doesn't determine at all the security of the data or the privacy of the data. You need to focus on those technical measures, on those contractual measures, on those organizational measures that will follow the data regardless of the location. Many elements of the global economy and the European economy rely on data flows. Think of 24 support services. Think about international medical advice, communicating now with family, getting help starting a business. Then advanced enterprise computing services rely on data flows for security, for resiliency, for advanced features. If you have customers or if you have employees overseas, you don't want to afford to have purer or less scalable or less secure services for them. You don't want to have silence. And then, last but not least, we need to understand that everything that follows forced data localization type Russia or China or the likes, it comes with trade-offs. It comes with functionality trade-offs. It comes with security trade-offs, because you can't have resiliency, business continuity, and then that allocated to only a certain region. That sometimes it's not compatible, and also you have a cost trade-offs. Ultimately, if the expectation of a country, not only Europe, I'm talking also again about those countries like trying to follow this model, that you're kind of forcing an industry to really deploy a bunch of things like support and infrastructure and a bunch of things around allocation, and ultimately it's a business. So the end user or the consumer or the enterprise customers will end up paying for that additional, losing some sort of the economies of scale that really underpin the cloud and make that you can run something very, very sophisticated at a low cost. So I definitely do think that data flows and having legal certainty around data flows and making sure that we can do things with innovation, technology, and respective fundamental rights, it's super important, and therefore this conversation today is totally relevant, and how we partner together as industry providers, customers, monitoring bodies, and you as people like you, Thomas, advising the both sides of the rope.
Okay, thank you for that answer. I think we have some participants with questions, and I believe Paul Reinrich was first. So I believe you can unmute yourself, Paul, and just go for it.
Yeah, thank you very much. And also thank you very much to Natalie for your insights. I have a question. So why are we talking via Microsoft Teams today, or in this meeting? So which measures can we take to be in line with the GDPR? Because of course, the normal data processing agreement is not enough. We are sure about it, and we asked Microsoft for a solution, and also we asked Microsoft for transparency, but we received no detailed answer. That's the challenge here. So do you have any measures from K&L Gates or also to the other participants? What can we do to be in line with the GDPR?
Yes, thank you. That brings it kind of down to the pain, actually. That's also where the whole code of conduct idea basically sets in, although it's not finalized yet. But you're actually, from a customer perspective, you're totally right. You have no other choice in this regard. You can just simply use a certain tool or don't. But you have no insight, basically, for what a certain service provider will be doing. And you will have to establish trust. There we are still lacking a reliable function for that at the moment. That's the simple and sad truth. That the tools, the reliable tools we had in the past, as Natalie said, were just erased, and nothing else was provided to us. And that's why, from my perspective, the answer at the moment, unfortunately, is you can make pressure to a service provider and say, please do that. But if they don't, at the moment, you simply don't have another choice than to go with another service provider. And that's not an answer I like to give as a legal counsel. And that's why we're all working to find better solutions here.
No, definitely. I totally can understand.
Comment on, like, I obviously I cannot speak on behalf of Microsoft, being from Google, but I would imagine that I have respect for their teams, their legal teams, their compliance teams. So maybe it's a matter of connecting with the right person. I'm not sure that we have it on the call today, unfortunately, but maybe I think it's a matter of indeed, setting in the right track to establish that conversation, risk assessment, how they can help, how they can support, what's the transparency tools they can offer to match EDPB's recommendations, but just making this comment because I know that the question was not addressed at me, but you said Natalie, so but I can only invite then Microsoft colleagues in the course to follow up separately.
Okay, yeah, thank you very much. I talked to you because you talked to before, so thank you very much. Yeah, this is a general challenge, I think, for all of us. So we are trying to use, or we were looking forward to use Microsoft Teams, of course. At the moment, we use Skype, but we all know, okay, Microsoft Teams, they store all the different files or some data in the cloud. We don't know which data, we don't know which kind of data, and we don't know how long they store the data. So this is quite a good challenge. And now our IT department is searching for a technical solution to make out of our data an anonymous data for Microsoft. But this is cost intensive, of course, and we are never sure if not Microsoft can maybe also see or have an insight in this anonymous data and can see what we are doing. So this is a challenge, I think, for all of us.
If I might chime in, sorry, my international data flow was cut off in the moment Natalie spoke about the importance of international data flow, so sorry for that. But now I'm back.
And resilience.
Exactly. Yeah, the topic that was just discussed, I mean, obviously it's not a problem of Microsoft Teams or Google Hangouts or WebEx or whatsoever is out there. It's a problem of all data flows, and I think we have to fix it. And I think one important point, I mean, first of all, SCCs are still valid. We all know, we read the Schrems II ruling. We can make our guess what is said about also SCCs there indirectly, but first of all, they are still in place. And secondly, we have to think about and that is exactly the code of conduct is one tool where we think we can find a solution here. We have to go into the discussions, and that's exactly what Natalie said with the EDPB, and see if we cannot find a solution where we maybe strengthen certain elements of data transfers and certain elements of processing of data in a third country, and we might not reach on every level the exact same data protection level, or maybe for very rare exceptional cases, maybe it might be different, but we can strengthen all other. Should we then really stop all data transfers? That is the question I would like to raise, and where I would like to go into negotiations with the EDPB, because I think somehow now a very rare exceptional scenario is blocking very important usage of data where it's not even really relevant for. And now we have to find a way to work with that. So that would be my take on it.
Yes, thank you. I just noticed we have other questions, and time is short. I know that. But Agnieszka, if you would like to ask your question, please.
Yes. Hi, everyone. I wanted to ask to the speakers. I mean, my question is not addressed to a specific speaker, and it's a very brief one. Which weight and room do you think the issue of international data transfer could take within the scope of a potential, or the negotiation of a potential EU-US trade agreement? I just finished attending a very interesting webinar organized by the European American Chamber of Commerce, and among all the other topics and the other issues like the digital web service tax, I mean the international the transfer of personal data from the EU to the US was, a big one. Thank you.
Yeah, actually, that moves it all to the politics area. And yeah, this is actually probably also another field where the struggle has to be decided. Whether the US is willing to make any kind of promises there, because as we know, one of the key issues is their authorities' conduct regarding personal data and certain excessive usage. And yeah, that will be a question if they are, this is a question of negotiation power, more or less.
Yeah, so sorry to interrupt. I wasn't asking for, obviously, I mean, sorry, probably my mistake, I didn't specify this. I wasn't asking, obviously, for a political opinion about it. My question was just, in your opinion, do you think this could be, could take which weight and which room this, topic could take in a potential trade agreement between the US and the EU?
Yes, that's actually a good question. Jörn or Natalie, do you have any thought or idea in that regard from your political experience, or?
I leave that to Natalie, if I may.
Well, I think indeed it's, you pointed out that one of the first steps that are being pursued as with the new Biden administration is to restore the transatlantic relationship, and this is one priority that both sides of the Atlantic want to pursue and do. Whether this will weigh in or has a factor into this potential trade agreement, yes, absolutely. And not only that, this will also impact all the landscape that we are discussing today, because the fundamental issue we're putting on the table is that the adequacy decisions are completely left on private hands, which creates tremendous challenges for everyone. So a new adequacy decision would solve, at least temporarily, this kind of problem, saying with whatever concessions the US is making, whatever changes, we consider these are adequate for the time being. We know that the US is in the process of adopting wider reforms like a federal privacy law, giving more competence, more power to the ombudsman, more independence. So I think it will be a step in the right direction in order to promote certainty and make our life a bit.
If I may chime in here also, it's a little bit off topic, I hope not too much. We're also quite involved in the whole GaiaX discussion, and sometimes people just put a very simplistic view on the things on the table by just saying, okay, we cannot process the data in the US, and let's just process it in Europe, but that's not the solution. There are a lot of European companies, they need to process data in the US, they need very low latency solutions. We're talking about edge computing, all of that also Europeans want to use in other countries, and also they want to make business in the US. And sometimes that gets kind of a spin that it's also like, okay, we just have to speed up and build our own data centers. That's not the solution here. So what I can answer here is only that we must find a solution, and we're working on one. We're putting it on the table, and we want to discuss it. And the nice thing is, our solution is a little bit away from the political thing, at least more than the other solutions. We talk directly with the EDPB, and let's see how they see the situation, because I saw also Natalie mentioned the discussion around right to audit. We found a very pragmatic approach within the EU Cloud CoC to solve that, where many thought it would not be possible. So I think there's a really good chance to come up with something that is acceptable for the EDPB, and then let's see how we deal with that.
Yes. Actually, I'm really looking forward to that. And yeah, I know we're a little over time, but we have one more question from Fabrice. So if you all have a little more time, I would just like to hear the question and see if we can answer it. Fabrice, you have to unmute yourself.
Fabrice, you're still on mute.
Okay. Fabrice, if you unmute, you can just go on. But yeah, as we're already over time right now, I really enjoyed the discussion because it's really interesting questions you're having here. And yeah, we are all in the situation of coming up with solutions and responses to that. So there is no final solution, unfortunately, to that. So that's why we believe this whole format may be interesting to bring together people from different angles who bring in their views. So from EU companies, from US service providers, from political aspects, and so on. And that's why we would like to further pursue this matter. Oh, Fabrice, did you unmute?
Yeah, yes, it's working.
Okay.
Thanks again for your patience, and thanks for this very informative presentation. I am leading the EU data protection practice, and we do a lot of development and implementation of binding corporate rules for our clients. And my question is in connection with the timing of code of conduct, because I am also convinced that in the long term, code of conduct will bring a lot of benefit more standardization and will be a quick way to reach compliance. But do you have any idea of the time frame to reach a consensus on this new referential of transfer from the various stakeholders of your initiative? Because many cloud providers already provide binding corporate rules. Salesforce, Atos, Capgemini are already on the market. Many providers who are using BCRs, and we expect within the 3 next months the update of BCR's guidelines from EDPB. But I wanted to have your view about the comparison of benefits from BCRs and code of conduct, and also maybe if you have some feedback on the time frame. I would be interested by your feedback.
Maybe I jump in the time frame, and then perhaps Natalie is best to discuss the comparison of the other tools. Perhaps when it comes to the time frame, so the original code took almost 2 years to negotiate with the EDPB. That's quite a long time, of course, but it was also about a lot of aspects, all data processing within the cloud. So and a lot of legal interpretation. So my take on this is, and since this is finished, there's a huge blog also finished that we can use for the data transfer tool. But my take would be, you cannot really extract something from the GDPR, how a supplementary measure looks like, how it really must be put on the market. You have to develop smart ideas and present it as quickly as possible to the EDPB and then discuss. So my take would be that we can go much faster, enter much faster the negotiations with the EDPB, but how that ends up and how long it will take, that I really cannot say. I mean, as we all know, also the guidelines for third country data transfer CoCs by the EDPB are not out yet. But I heard already that there's a huge interest in it. But having said this, or to wrap it up, I think shorter development phase and entering quickly in the negotiations and see if we can develop smart ideas or bring in smart ideas that we develop and negotiate with the EDPB.
Yes, that kind of sums the future process up pretty good, I believe. So knowing that Natalie has a sharp appointment and has to leave actually, I believe this is quite a good point to stop it for the moment, only of course. And yeah, as this is an ongoing series, I would be very glad if many of you attend next session. Perhaps if you think about what happened today, you may also have some follow-up questions. Perhaps it will be possible to respond to them or discuss them in the next episode, although we will have probably one specific aspect we want to discuss, but we can also probably go back to general questions in this regard. And yeah, we will of course inform you on what's going on in the series, so we will know upfront what's happening. And yeah, that brings me basically to the end of this. I want to thank all the other speakers and contributors, in particular Natalie and Jörn, of course, who have provided very interesting and brilliant answers, I believe. And yes, that's it for today. Hope to talk to you, see you all soon in this format or perhaps another format.
Thank you very much, everyone. Bye-bye.
Great. Thank you so much, everyone. It was a pleasure. Bye. Have a great day.
Bye-bye.